to keep them safe, and I commend the bill to the Senate.
Thank you, Senator Patterson. Senator McLaughlin.
Deputy President, I rise to speak to the Counter-Terrorism Legislation Amendment High-Risk Terrorist Offenders Bill 2020. The bill seeks to amend the Criminal Code Act, or the Criminal Code Act 1995, to introduce the concept of an extended supervision order, which may be imposed on terrorist offenders if they are released into the community, and on a balance of probabilities, if the court finds that they pose an unacceptable risk, they can apply various conditions on the individual. And there's also ancillary amendments in the body of the bill which expands monitoring and surveillance powers to support this initiative. As an old defence lawyer, these types of bills do always put a shiver up my spine. They always have the language of Orwell, and they should be considered at great length before passing any parliament. In this instance, in my review of the bill, I have found comfort not only in the process of the bill outlined by my friend and colleague Senator Patterson. It is not a knee-jerk reaction to a supposed problem. It is a real problem. The foundation stone of this initiative is that there is an existing and increasing terrorist threat to this country, as groups seek to take away and challenge our liberty with asymmetric warfare. And as my other colleague and friend, Senator Molan, has expressed, it is only going to increase, unfortunately, and become far more complicated. Also, which gives me comfort in relation to this bill, is that the parliament has already decided to have this type of order. So it would be presumptive of me as a new member of the Senate to rail against an order when the parliament has already settled on a regime of this nature. In fact, this provides an additional, less restrictive option for the courts, not only because there is a potential possibility for a person that will not reject their ways of evil and violence, that they may fall between the current legislative regime and return to civilian life, but also because it is less restrictive and gives greater options. We have already in this country control orders, interim control orders, preventative detention orders and continuing detention orders. So the fact that this is less restrictive and provides a less restrictive options should find favour with members of this Senate. It has gone through the Parliamentary Joint Committee on Human Rights. It has been examined by the Senate Standing Committee for the Scrutiny of Bills. It comes from a suggestion of the Independent National Security Legislation Monitor, and it, of course, has been subject to an inquiry by the Parliamentary Joint Committee on Intelligence and Security. The Parliament and this Senate has worked hard to bring this bill to the chamber without any unnecessary oppressive conditions and sought to balance the rights of the individual against the needs of the collective. That is, of course, always a difficult conundrum. There were two aspects of the bill which were, if I can use the term, debated by the various committees. One was that this is a form of punishment. There's always an objection if a person commits a crime, they are then tried, found guilty and punished, that once the punishment is complete, they shouldn't be punished again. The rationale for the bill by the government, and it has some merit, is that this is a control order about future risk and not a compounding punishment. You have to accept that principle to accept this bill. I dealt with this sort of ethical dilemma when I was in State Parliament and similar legislation was brought in by the Labor government in relation to sex offenders who weren't rehabilitated but leaving prison and posing a significant risk to the community. And the Parliament similarly settled on a like rationale. The other aspect of the bill which was subject to much debate, again in the committees or dialogue between the various parties, was the concept of the lower burden of proof on the balance of probabilities, that there was an unacceptable risk or likelihood of an unacceptable risk. And the government's view, which was accepted by members of the committee in its dialogue, in many of these committees in their dialogue, was that this is a lesser condition placed on the individuals. The others are detention orders, and thus should have a higher burden. This is a less restrictive condition, which allows potentially these individuals to return to the community, albeit under particular reporting conditions and or surveillance. So again, the resolution or the landing of both the government and the various committees has given me comfort, and I appreciate also the comments from across the aisle from members of the Labor Party, similarly taking a view that we appear to have landed at least in a position of some balance. Now, speaking of balance, I've always had an interest in the debate about liberal democracies restricting individuals' rights in the pursuit of the collective security. It's a fascinating topic, and there are, dare I say, hundreds, maybe more, articles on this topic. And in my reading, when contemplating my comments tonight in the debate, I came across an article by Christopher Michelson, if I hope I've pronounced his name correctly, and an article in 2006 which was Balancing Civil Liberties Against National Security. He argues, interestingly, that the dichotomy between civil liberties and restricting them for national security is a false dichotomy, a false debate, and not a rewarding one that will lead you down the path of a rational conclusion. And in fact, he points out that people always argue that we must curtail civil liberties to combat terrorism, and on the flip side, others argue that if we curtail our liberties, we know better than the terrorists. That's an oversimplification of a complicated argument. But he does cite various aspects of German law, and I do not profess to be an expert in German law at all. It is something I have never studied. I do have a degree in Scots law, but it's unhelpful this evening. But German constitutional jurisprudence uses a proportionality test, and it consists of three main requirements. Any curtailment of constitutionally protected civil liberties and human rights must generally be 1, suitable, 2, necessary, and 3, appropriate. I only raise this point for the benefit of members and perhaps their future reading, but I think even if you apply that test, having regard to the various reviews by the committees, this bill should find favour of the Senate.
Thank you, Senator McLaughlin.